The last topic of Chapter 9 and Section 3 is how are people sentenced? The federal government has conducted and does conduct surveys on sentencing practices throughout the states and the federal courts. There's a lot of statistics in the book. I have some up here on the slides. 1 million adults are convicted of felonies each year. 70% are sentenced to periods of confinement. The average sentence is 4.5 years. The number of convicted felons being sent to prison is lower than it was a decade ago. In 1991, we discussed this, in 1991 is when crime rate has really hit its peak and has been on the decline. Crime rate has been on the decline ever since, so that makes sense. But the average time served per offense has not decreased substantially. So I will let you review the charts. I have them here, and they are also in the book. We won't go through them all, but it's certainly good information to review. I want to start with factors affecting sentencing. I touched on factors as I was discussing the types of periods of incarceration. Certainly, there are other sentencing options available. Court can impose fines, community service, supervision, i.e. through probation or parole, treatment, conditional sentences, and so forth. But what are the legal factors, or what are the factors that courts consider? And there's a number of those. The legal factors, the offender's criminal record, where the offender used violence, whether the offender used weapons, whether the crime was committed for money. These are legal factors that are considered. I want to touch on the criminal history, right? If a defendant has a grand larceny first offense, or even a burglary first offense, maybe the offender's position is they did it to get money to buy drugs, they may not end up in prison. They may end up with probation. That's what the court looks at for criminal history. However, the court looks at somebody's criminal history and they have several different crimes in a very short period of time, then that's going to affect what the judge is going to do. Weapon and violence, that is certainly something that plays a role, significantly plays a role. I will let you, again, assess the percentages of crimes, who goes to prison, who goes to jail, which is less than a year of incarceration. It's usually in a local facility like a county jail, and the who goes on probation. And it's comparing felonies, nonviolent felonies, compared to violent felonies. And as you can see, as more convictions occur on either realm of those, as more convictions occur, multiple felony convictions, the time in prison goes up. The more likely one goes to prison goes up as well. So let's talk about other factors, the extra legal factors, not the legal factors, which we just kind of covered. Social class, offenders' characteristics, we'll kind of lump them together. Social class, the judge, as part of that pre-sentence investigation report I mentioned in the last lecture, one of the things that the probation department does is to interview and learn about the offender. And they may not only just interview the defendant, but family members as well, to confirm what the defendant said about family background. So, social class, how they grew up. Were they from an abusive home? Poverty? Education? What's their level of education? The research does show that it does have a bearing on sentencing, specifically whether or not a prison sentence will be imposed. The higher level of education, the less likely to serve prison. However, if someone is sentenced to prison with a higher education, the length imposed isn't a factor. I would imagine that is because they're kind of set by statute. And that is actually an accurate reflection. I represented folks on both ends of the education spectrum. I represented a doctor who had several DWI offenses. And when you have so many in a short period of time, you face going to prison. And I have seen, and this individual was not, and much to my surprise, because in the folks who are less educated would go off to prison. But this individual got probation and had to serve a handful of weekend time in jail. So it certainly plays a role. Gender plays a role. Women are sentenced less to prison than men, especially if they're a single mother. Women charged with sex crimes more lenient than men who are sentenced to the same kind of crimes. I will say, I guess it's going to be dependent on where the research is taking place. However, in this county, men or women, if we're dealing with a drug-related case, a drug possession, men and women are treated the same. Actually, men and women are treated a lot of the same, and I think that's changing with time. Age plays a role. A 17-year-old who's tried in an adult court versus a 29-year-old, the same crime. The significance behind that would be the older person should know better. The older person is more likely to accumulate a criminal record. But I have seen young people get a harsh sentence, and I believe it comes from the court trying to scare them. This is the one and only time we'll see them in the court system. Race plays a factor affecting sentence, unfortunately. It's no surprise that minorities are sentenced more to incarceration than Caucasians. But is it due to judicial bias or some other factor? Minority groups may go to prison more often because they commit more crimes, possibly. And then there is the race of the victim that plays a role. That could play a role in whether or not somebody is incarcerated. Research shows that minorities who kill Caucasians get harsher penalties than if the victim was a minority. The association between race and sentencing is very complex. But there's no question that the defendant's race shapes the contours of justice. And unfortunately, the effects are devastating. And I hope we see some changes in light of what our country has been through, especially in the last 6 months and what we've seen. Other factors, victims' characteristics. Victims are allowed to speak at sentencing. There is it's called a victim's impact statement. Sometimes they just write a letter and it gets read by the prosecutor, or it gets attached to the pre-sentence investigation report. But sometimes they come to court and they speak about how they are effective. And the question is it powerful? And I will say absolutely yes. There is nothing like hearing the victim talk about how the crime affected them to affect the judge who is sentencing. The individual that I referenced at the beginning of this lecture, not this one in this chapter's lecture, Larry Nassar, the doctor who was he was the physician for the female Olympians. Every single one of his victims and their family spoke at length. It took hours. They'd get up one by one and saying how the crime affected him. At one point, the defendant, Mr. Nasser, asked the judge to make it stop because it was affecting his mental health. And the judge was like, yeah, I don't particularly care about your mental health. But yeah, it does. And the book indicates that the research is mixed, how it would affect, but I have seen judges firsthand hand down max sentences after hearing from the victims. I've seen it in child abuse cases. I've seen it in a stalking case where a woman was stalked by a man who's never had a criminal record. He had an excellent job and education. He was an older fellow. He was in his 50s, never been in trouble before, but for whatever reason engaged in some horrible behavior in stalking and breaking into this woman who broke up with him garage. He was not in his right frame of mind for sure, but she came to court and she spoke about how it felt, and she wanted him off the street, never to bother her again. The judge handed out a max sentence for someone who had no criminal record, and they weren't violent crimes. Stalking's not a violent crime, and neither is well, actually in that case the burglary was, because it was her home. But still, that was shocking. Page 237, Victims' Impact Statements. The assignment this week is going to review that, pros and cons, and be part of the written assignment. When it comes, this is also part of this week's assignment too, the next thing that's coming. Now this is, this here is from the book. When it comes to sentencing, judges are human too. Whether consciously or unconsciously, they base their decisions in part on other factors, many of which are not related to the crime itself. So the question is, what are the consequences of this, and can anything be done to limit the influence of extra-legal factors on sentencing? And let me give you another example to think about as you're thinking about this question, which will be in the forum post this week. The prison break, the Dannemora prison break from the Clinton Correctional Facility. I hope that you guys all have heard of that story, or that case. And there was a female civilian worker, Joyce Mitchell, who worked in the tailor shop, who assisted those folks in escaping, the two gentlemen who escaped. But there was also another worker who was a CO, a corrections officer, and he had been at the prison a very long time. I think it was close to 30 years. And he was arrested for assisting bringing in tools for these inmates and letting some of the rules of searching be kind of laxed a little bit. He was more buddy with more than one of the inmates, but definitely one of the ones that escaped. And he was arrested as well for assisting in their escape. They were charged with the same charge, both the female civilian who was working in the tailor shop, Joyce Mitchell, and the CO. And they were both sentenced with different judges in this county, Clinton County. Different judges, and she got the max prison sentence, and he received a 6-month jail sentence and probation. And the judge said there's no reason to send a CO to prison where more problems could happen for this individual, because this individual was a CO. That was part of the reasoning. But the question is, was that fair? Is that the judge using a different basis? Same crime. Neither one had been in trouble before. Both allegedly did the same thing and pled guilty to it. So those are some of the things you gotta think about, because there are a lot of people who say that wasn't particular, that Miss Mitchell got what she deserved, but that the other sentence was a little lighter than necessary. All right, let's talk about a very controversial topic, capital punishment. Death, right? This is a punishment. It's the most severe sentence one can receive in the United States. The federal government still uses the death penalty up until recently, when the current president signed an executive order reinstating the practice. One of the last executions, and it was by lethal injection, was in 2001. Timothy McVeigh, he was the individual who was responsible for masterminding and blowing up the federal building in Oklahoma City, killing 168 people and children. It hasn't really been in play much. The Obama administration didn't appeal to that administration, so it wasn't used all that often. But now it's been certainly reinstated by the current administration. More than half of the states still have and use the death penalty. There's a chart in the book on page 231. You can check it out. Most countries, especially the developed countries, have abolished it. Only 57 have retained it, and that includes the United States. I'll give you a list of the company that we are in with the death penalty. The Supreme Court has limited the death penalty to first-degree murder convictions, and then it is only when there are aggravating circumstances that exist, like hiring someone to murder somebody, or where the murder itself was extremely cruel, or something like blowing up a building and lots of people dying. This is one of the most controversial topics in the criminal justice system, and maybe someone will write about it. I believe it's one of the topics that you can choose. And there are a number of reasons for it and against it. So here's the chart of the executions since 1976. I'll let you look through that. It's in the book too. Let's talk about the arguments for the death penalty. Now, these are arguments. These are not my personal opinion. These are arguments for the death penalty. Deterrence. People don't kill for the fear of being killed or committing serious crimes. People, that's their fear of being, that's the deterrence, that people don't kill for fear of being killed. It's pretty final. An offender can't reoffend, right? That specific deterrence. If the point is to deter the specific offender from committing the crime or reoffending, it's a little hard to reoffend if you have been sentenced to death. General deterrence. Having a death penalty will cause the murder rate to decline, because the decline drastically shows once it's well publicized, an execution is well publicized, the research shows that there's a drastic decline. These are arguments. We'll see on that one. Morally correct. Few arguments in support of this claim. It is mentioned, the argument is, it's mentioned in the Bible and other religious texts. The Constitution does not forbid it, and in fact, when the Constitution was written, death was an acceptable and widely used form of punishment. It provides the greatest justice for victims. I tend to share a lot of my stories. I hope that's over a lot of my cases. Hopefully it helps to put it in context, and it's real. I represented an individual who intentionally killed someone else senselessly. The victim was an elderly woman. My client was late 20s, early 30s, young man. And the family spoke at sentencing, very powerful. And they were stating how much they wanted there to be a death penalty. But it's not an option in New York. New York does not recognize the death penalty. But they wished that it was available in this particular case in that my client received a death penalty. The court sentenced him to life without parole. So morally correct. It's certainly a view when you're a victim or a family member of the victim. It certainly plays a role. Lastly, it sends the statement that the offender's conduct is so unacceptable to the community that one who engages in it forfeits the right to live. That's another argument on the morally correct side. It's proportional to the crime. If punishment must be proportional to the seriousness of the crime, then it follows that the more serious punishment should be imposed for the most serious of crimes. The manner or cruelty in which the victim was treated must be considered before considering cruelty or brutality the offender faces. So it has to be proportionate to the crime and how was the victim treated. And I will tell you, in the case when I said that my client intentionally killed someone senselessly, he planned it. He went to her home, knew how to get in because they were neighborly. They lived in the same neighborhood. And he stood over her bed while she slept and hit her with a sledgehammer. That all plays a role. How it happened, how the victim was treated. Reflects public opinion. There's an argument for the death penalty. Research shows that most people are in favor of the death penalty under some circumstances, and those circumstances are the most heinous of crimes. And maybe if New York did recognize the death penalty, that case that I just described to you could have fallen within the most heinous of crimes. Unlikely chance of error. This is just an argument, despite what we hear in the media or see in documentaries, the appeal process and legal controls almost make it impossible for an innocent person to be executed. While they do recognize, under this view, while they do recognize there have been mistakes, courts are more likely to rule in favor of a defendant and removing the death sentence than allowing it to stand. That's the argument. The unlikely chance of error. And those are arguments for capital punishment and the support of capital punishment. Of course, there are several and good arguments against the death penalty. Now you're going to see some of the same of these, but flipped on their head. Arguments against the death penalty. Possibility of error. We just ended with error. Now this argument is saying there is a possibility of error. Research shows that due to DNA evidence that now is available, and more justice groups are aimed at exonerating people convicted of crimes they did not commit, there are nearly 10,000 people each year that are wrongly convicted. With pressures to solve homicide cases, ineffective defense attorneys, prosecutors who don't always turn over evidence that the law requires them to, the probability of executing an innocent person is high. And there is evidence that some innocent people have been executed. And that's the argument against death penalty, this possibility of error. Now let me give you some real cases. Former Pennsylvania death row prisoner Kareem Johnson has been exonerated 13 years after being wrongfully convicted and sentenced to death by a Philadelphia jury on July 1st, 2020. This just happened. On July 1st, 2020, the Philadelphia Court of Common Pleas completed the exoneration, formally entering an order dismissing all charges against him in the capital case. On May 19th, the Pennsylvania Supreme Court had barred his re-prosecution because of prosecutorial misconduct that exhibited a conscious and reckless disregard for his right to a fair trial. So that was on the prosecution. Doesn't say what the prosecution did. But here's some telling news. Johnson is the third death row inmate exonerated in 2020. In 2020, the third one in 2020. And the 170th death row exonerated since 1973. So, arguments against the death penalty, possibility of error, weak public support. Americans approve the death penalty, but over the years the rate of approval goes down. Those that support it in principle believe it shouldn't be used unless made foolproof, i.e. that no innocent people be executed. The argument for little deterrence. The threat of the death penalty has little effect on murder rates. The argument's based on inconclusive research one way or the other. It is hard to know what a criminal perceives as the risk. Are they more likely to commit murder if the punishment is life without parole? Like being locked up until they die? Is it any different? I'm just going to be locked up for the rest of my life until I die? Is it any different, a deterrent, than being killed or executed? Race, gender, and other biases. Men are more likely than women to get the death penalty for the same crime. African Americans and minorities are more likely to receive the death penalty than Caucasians. Homicides between strangers more likely to get death penalty than murders involving non-strangers. So, the biases that exist. Argument against the death penalty. It causes more crime than it deters. It may put police officers in danger. If a criminal kills a victim in a botched robbery, then they already know they're facing death, so they have nothing to lose. So what do? They just go out shooting. They shoot at cops. They continue a killing spree. So, and the other side of that is also, if the state can kill people for breaking rules, i.e. executions, then why can't I kill someone who wrongs me? Right? It's that kind of attitude. Doesn't really deter, causes more crime than it deters. Cruel and inhumane, causes extreme pain and takes longer to cause death. There are also psychological factors, sitting alone on death row, waiting for your date of execution. So there are a number of them. How about this? It's abandoned by most developed countries. Like I said, 57 countries still have it as a potential punishment, and the United States is one of those. So let me tell you, I'm not going to read the whole list of the other 56, but I'm just going to point out some of the countries we're in company with here. Afghanistan, Nigeria, Iran, Japan, Taiwan, Kuwait, Libya, Thailand, Uganda, Bangladesh, Iraq, Indonesia, Cuba, Yemen, Saudi Arabia, Vietnam, South Sudan, China, Somalia, Malaysia, Pakistan, Singapore, North Korea, Belize, and there's the list, the list goes on. But you don't see France, right? You don't see Italy. You don't see some more of the developed countries. It's expensive. The appeals and the appeals process for death penalty cases, they're long, they're lengthy, and they're costly. It takes about 12 years to go through the process of a death penalty case, through all of the hoops that someone gets to go through. And it's morally wrong. It's brutal, and it's demeaning, and it's just social vengeance. And despite early religious support for it, the more recent trend from religious leaders is to condemn the practice. All right. Whatever side of the coin that you are on for capital punishment, it will always be a topic of contention. Page 236, Supreme Court decisions involving the death penalty. They're important, and you should know the principles. You don't necessarily need to know the case names, but you should certainly know the principles. And I'm going to go through those principles. I'm going to summarize them here. Actually, might even have a little chart on here in the end. Punishment of death for the crime of murder does not violate the Eighth Amendment. For cruel and unusual punishment, 1976. Mandatory death penalty laws, where it's mandated by statute, someone convicted of killing a police officer in the line of duty must be sentenced to death. That's an example. So mandatory death penalty laws are unconstitutional unless there are aggravated and mitigating circumstances, meaning, for example, tortured the officer and trying to shoot yourself out of a robbery that's gone bad, or just shooting willy-nilly. You cannot have a statute, a law that says someone convicted of killing a police officer in line of duty must be sentenced to death. You can never have mandatory punishment of death. Okay, the court has to consider aggravated and mitigating circumstances. Rapists cannot be sentenced to death. There's no penalty for the crime of rape. Here's the list of cases. Defendant must be allowed to present all mitigating evidence pertaining to his or her character, record, and circumstances of the crime. It is unconstitutional to impose the death penalty on a person who commits a felony that results in murder without considering the person's intent. This is an important one. It is unconstitutional to impose the death penalty on a person who commits a felony that results in murder without considering that person's intent. That's the Edmond versus Florida. I'm going to tell you about that case because it's important. While Earl Edmond sat outside in a getaway car, his accomplices, Sampson and Armstrong, rang the doorbell of the home of Tom and Eunice Kersey, who lived at a farmhouse in Central Florida. When Mr. Kersey answered, Armstrong held him at gunpoint while Miss Sampson Armstrong, his accomplices were Sampson and Jeanette Armstrong, husband and wife team. They rang the doorbell of Thomas and Eunice Kersey, who lived at a farmhouse. When Mr. Kersey answered the door, Mr. Armstrong held him at gunpoint while Mrs. Armstrong took his money. Eunice came out with a gun and shot Mrs. Armstrong, which just wounded her. But Mr. Armstrong shot back and killed both of the Kerseys. The Armstrongs took all of the Kerseys' money and then went back to the getaway car Edmund was driving. So Edmund and the Armstrongs were indicted for first-degree murder and robbery. The judge instructed the jury that under federal law, killing a human being while engaged in the perpetration or an attempt to perpetrate a robbery is first-degree murder. The Armstrongs were convicted of first-degree murder, and at a separate penalty hearing, the trial judge found that the murders were committed for pecuniary gain and were especially heinous, atrocious, cruel, and there were no mitigating factors, and sentenced them to death. And then he sentenced Edmund to death too. And on appeal, the Florida Supreme Court rejected Edmund's contention that his death sentence was inappropriate because he did not kill or intend to kill the Kerseys. It held that felony murder rule and the law of principles combined to make a felony generally responsible for the lethal acts of his co-felon. So then the Supreme Court took the case, and the issue that they had to answer was whether death is a valid penalty under the 8th and 14th Amendments for one who neither took life, attempted to take life, nor intended to take life. And the majority found that the record did not support a finding that Edmund killed or attempted to kill the Kerseys. And the record does not support a finding that Edmund intended to participate in the killing or facilitate the killing. And that, as a result, he only aided and abetted a felony with regards to the robbery. And that was deemed unconstitutional to sentence him to death without considering his intent in the actual killing. So that was that particular case, Edmond versus Florida. You need to consider somebody's intent. Death by electrocution is not cruel and unusual punishment. An insane person cannot be executed, but they have to be insane at the time of the crime. Okay? Or becomes insane. An insane person cannot be executed at the time of the crime or if they later become insane. Mentally challenged person cannot be executed. The jury must find the aggravating circumstances necessary for imposition of the death penalty. We discussed this under the enhanced sentence. Remember, if there are facts requiring the enhanced sentence to death, that's the job of the jury, beyond a reasonable doubt. If the person committed the crime while under the age of 18, no death penalty. Cannot sentence that person to death penalty. Death by lethal injection was deemed constitutional. A child rapist cannot be sentenced to death if the crime did not result in or was not intended to result in the child's death. I didn't go through all of those cases. I'll let you go through them. Those are the, they're all important, but those are the highlighted ones I think you should be aware of. So that ends Section 3, Courts and Adjudication of Crimes. The final section, Section 4, is going to cover corrections. It's the final component of the criminal justice system. We did our C for cops or C for courts, and now we're going to move on and finish up with corrections.